Well, good morning or good afternoon, everyone, depending on your time zone. Welcome to today's nonprofit organizations group webinar for Venable here. It's called Managing Risk for Nonprofit Meetings and Events in 2025. I'm George Constantine, and I co-chair the Venable Nonprofit Organizations Practice Group along with Janice Ryan. And it's my pleasure today to introduce our speakers and get the session kicked off. But before doing so, briefly, I wanted to give a mention about next month's webinar. We will have one on May 21st addressing nonprofit organizations and compliance with IRS audit and examination procedures. We thought this topic would be a timely one given the news lately. And so that'll be on May 21st. We haven't sent out an invite yet, but we will shortly. So be on the lookout for that email. So back to today's topic. This is an issue that is a common one that comes up very often with our nonprofit organization clients, how to manage risk in all different ways, shapes, and forms when it comes to nonprofit organizations, meetings, and events, which we all have very many of. The two of my colleagues here who will be presenting are individuals who work very regularly on nonprofit organization meeting issues, and you're in for a treat with their presentation. I'll introduce them briefly now and start with Andrew. My colleague Andrew Steinberg is a partner in our practice, and I've worked with him for, I think, 11 years or more now, and he regularly advises nonprofit organizations on all the usual legal matters that come about, and that includes many of these issues that we're going to talk about today. Also presenting today with Andrew is our colleague Brian Melnyk, who's an associate here at Venable, and he also works very frequently on these types of issues. Particularly, Brian has done a lot of work on contract reviews of hotel and convention center agreements, and advising nonprofit clients on both the risks and opportunities that can arise out of those types of contracts. In addition to this sort of work, Brian also works regularly on compliance with laws governing political law and lobbying activities. And Brian actually served briefly as a staffer of the House Committee on Education in the Workforce before he came over to Venable. So you've got two great experts to speak about this topic. And without any further ado, I'll turn it over to Andrew to get things started. Thanks.
Great. Thanks, George, for the warm introduction. And hello, everybody. Appreciate you being with us today. We know how significant meetings, conferences, programs, and similar events are to the lifeblood of revenues for nonprofit organizations. And so we're going to give an overview today of a few different event-oriented topics that we regularly see come up in day-to-day operations of nonprofit organizations. We'll cover some emerging issues and recurring issues that we've seen. We'll provide you with some general best practices for negotiation, as well as what we're seeing from event venues in terms of their receptiveness to requested changes. We'll also cover with you commonly seen provisions in meeting facility contracts, both for hotels and convention centers, the key differences, and what those central provisions really mean. And then we'll close with a brief summary of attendee code of conduct, which has become more in vogue lately to ensure that events remain a safe and welcoming environment for your attendees and staff. In terms of recent trends, we've seen a few issues as of late, and I think one thing we've seen a lot of in the past few years concerns reports of suspected misconduct or unprofessional conduct by people who are attending your events, whether they're members of your organization or leaders in your organization or unaffiliated with your organization or even just a staff member of your organization. And what's really important is that your organization have a policy in place that outlines what types of behaviors are prohibited, and that you outline a clear process for how those complaints are going to be reviewed and evaluated. Ideally, you want to have attendees agree as part of the registration process to those terms of expected behavior, and that you properly investigate all complaints that are brought in good faith. And what's really critical as complaints of misconduct, whether it ranges from bullying or some type of physical incident or sexual harassment or over intoxication at an event. It's really critical for your organization to carefully review all complaints that are received, and to treat them with the appropriate formality. It's not possible to dismiss away complaints as being minor, and there really is a duty to investigate as soon as a complaint is brought forth. Another trend that we're seeing concerns standard limitations of liabilities and commonly seen vendor contracts, whether they be for catering or audiovisual services or event registration services or any number of the other support services that you may seek to contract for to support the running of your event. And agreeing to low liability limits can impair your ability to recoup damages in the event that a given business relationship doesn't work out. And while not every agreement needs to have the same limits of liability, and it's ultimately a business decision about what types of risk comfort should be accepted for a given relationship, it's important to pay attention to the terms and make sure they're configured to an organization's risk tolerance, given the nature of its event and the nature of the service that's being contracted for. For those of you that might run events with other organizations, either as a jointly run program or a co-located program, it's really important to have terms that clearly memorialize at the outset the relationship between the parties, how decisions about the co-located or joint event are going to be made, what the financial responsibilities are of the parties, and how disagreements are going to be resolved. And I think importantly, what happens if one party wants to withdraw, and how is the financial risk of that withdrawal decision going to be allocated between the two participants? We've been seeing more recently, especially as there's been economic uncertainty with current economic conditions, events being canceled or partners seeking to change the scope and scale and size of an event or withdrawing altogether. And it's important that your organization have an appropriate agreement in place so it's not left hanging dry in the event a business partnership doesn't work out as initially intended. We've also seen in response to certain governmental policies, either attendees or vendors boycotting certain cities and states as event locations based on emerging political issues. We've also seen boycotts of particular venues, primarily from workers of those venues. Both of those issues have affected nonprofit organizations, both in terms of the due diligence that should be carried out when identifying a potential event site to host an event, as well as in the weeks leading up to an event, and ensuring that an appropriate plan is in place to mitigate the effect of any type of labor action, not only from the perspective of reputation risk associated with the event or the use of a site, but ensuring that the services and facilities that were contracted for are going to remain available, or that there are measures that are in place to mitigate the impacts of any type of action. And then lastly, we continue to see phishing of room reservation and mailing lists. And oftentimes your attendees will receive scam solicitations indicating that they can book a room for your event, or that the event registration list can be acquired at a fee through a third party that's wholly unaffiliated with you. And we've seen attendees have fallen prey, unfortunately, to these increasingly sophisticated phishing attempts on your attendees. And we think it's important to warn your potential attendees about how official communications around event booking will be available and where questions can be directed, and that you're aware that these types of phishing activities might be present to provide a warning. It's also critical to detail and document what your privacy policies and practices are with respect to the sharing of event attendee data. Either you don't share it or you don't sell it, or if you do, that there are appropriate disclosures that are encapsulated in your privacy policy that give you appropriate permissions to utilize and share attendee contact information for the purposes that you want to use it for, including selling it to a third-party sponsor, for example. So, in terms of a few just general negotiation tips, not every single event is the same. And it's really important to determine what's most critical for your organization and what it's hoping to achieve in the context of any negotiation. In some cases, that might be more flexible cancellation or attrition terms. In others, it might be purely about the business financial terms, such as room rates or guaranteed food and beverage minimums, or the imposition of additional surcharges and fees to help avoid cost creep. And so I always recommend to organizations that they consider what is going to be most important to them as they approach a given negotiation for an event venue or an event vendor. Of course, competition can help with ensuring that you're getting the best value and the best possible service. And you can consider bidding for multiple vendors and engaging an outside conference consultant to help solicit your bids so you get the most competitive offers. And that's really intended to try and maximize your bargaining power in selecting your event sites. I always say that location, dates, and time of year are really critical. Some cities are known as major event host sites. Smaller cities that are second tier or third tier for professional conferences and events may be more willing to negotiate with you and give you more favorable terms in order to try and win your business. For many sites as well, the time of year matters. This month, next month, September and October are normally peak meeting months, and meeting around rather during a peak visit may help with cost savings. And the time of the event, weeknights are normally more expensive than weekends, and consider whether weekend meetings may help achieve cost savings. In terms of helping to manage liability with your vendor contracts and your venue contracts, it's important to be mindful of the entire ecosystem of agreements that are in place for a meeting or event and how they work together. And so you may have an agreement with an event venue that requires all of your subcontractors to maintain certain levels of insurance, but it may not be appropriate for each and every subcontractor to have the same type of insurance that's required of you as an event host and the primary provider of the event. And so it's important to pay attention to those types of terms, to negotiate them, and to ultimately shift and allocate responsibility for compliance downstream. That includes ensuring that your vendors have appropriate insurance coverages and policies, that there are appropriate indemnification terms, that you've done appropriate due diligence on your service providers. And I think most of all, it's always a negotiation, and you shouldn't negotiate against yourself. And in some cases, if you're not getting what you want, you should be ready to walk away or look elsewhere. And I think to try and maximize bargaining power, one thing that we see and suggest is trying to negotiate further out in time in order to negotiate multi-year deals to bring an event back to the same place every certain number of years. And if you achieve a balanced agreement with a venue site that you're going to use on a recurring basis, it can make your contracting process in the future far more efficient and less costly on an administrative basis. We're going to dive a little bit now into some of the key provisions that are commonly seen in the event venue agreements. I'm going to turn it over to Brian to walk you through some of the key terms.
Sure. Thank you, Andrew. So as Andrew mentioned, there are a number of notable provisions in these contracts. Oftentimes, these event contracts, either with hotels or convention centers, are lengthy, but there are a few provisions that, and while all the provisions are important, there are a few that are either common in most every agreement or require special attention to ensure that your expectations are met when you're hosting an event. So we'll go through some of these listed on this and maybe a few others that aren't. before we move forward. Andrew, please feel free to jump in if you've got any additional comments as well. So the first here, and perhaps one of the more most important, is the rates and additional fees that you as the organization will be paying for either hotel rooms, so that's room rates, conference center or conference meeting space, and then also secondary rates like and additional fees that you need to consider, like setup and equipment fees, rigging, exposition, vendors, etc. Those are all important things to look at to make sure that the contract reflects what you have been negotiating with the hotel or conference convention center, to ensure that everyone's expectations align and that you're not hit with any surprises. With respect to rates and with respect to hotel contracts specifically, you may want to consider putting in a provision, what we call a lowest rate warranty provision, that guarantees that if you're holding an event on a particular range of dates, that if the facility is large enough to accommodate multiple events over that same time period, or even if not, that your group is guaranteed the lowest rate being offered during those time dates. That's something that's often not in a form agreement that you get from one of these event facilities, but it's something that we recommend that you consider adding in to ensure that you're getting the best deal possible. The next thing here is room block adjustments and audits. And this is separate but related to attrition, which we'll talk about in more detail later on in this presentation. But with respect to this bullet, I think the big thing to keep in mind is how to maintain flexibility for your organization in light of changing circumstances, changing outlook on how many folks will be attending your event. And so we often encourage our clients to include provisions in the agreement that allow maybe a year or 6 months out from the actual event dates to assess kind of what the room uptake is, what the conference center or what the conference registration pickup looks like, and then add a provision that allows the host or the sponsor of the event to adjust, either lower the amount of space that they need or increase the amount of space that they need if event registrations or room pickups are exceeding what was originally anticipated. And along with that is the importance of room and registration audits. So oftentimes there will be a central reservation method for your event attendees to book a hotel room or register for the conference itself. But sometimes folks fall through the cracks. They don't listen to all the instructions, and they might make room reservations that fall outside that central process. And so it will be vitally important for you to communicate with the hotel and to essentially get an audit of who's booked for the event, comparing their list of names and folks who are staying in the rooms or attending the conference versus the sponsors' records as well, to ensure that there aren't folks that you're not getting credit for in the room pickup, for example.
And that can become really important when you have room block reservations that's not an entire buyout of the facility, and maybe your room block is sold out on a night and you have a latecomer who registers outside of the block, and then later you have underperformance for those individuals who registered earlier. You want to make sure that you're getting counted for all of the room nights that you're bringing to a given venue or property. Also just to make a point about some of the room block adjustments, if you do obtain that type of right, that adjustment should be without penalty for reductions, and to secure increases at the negotiated group rate rather than the prevailing room rate at the time. And in the event that a room block adjustment is affected, that there should be a corresponding adjustment to any attrition commitments or cancellation commitments based on the room block adjustment that's been affected rather than the original room block. And that way, your cancellation and your underperformance obligations will vary in case of any adjustments.
Thanks, Andrew. That's really important. Another provision that is important to keep in mind are force majeure provisions, and these are provisions in a contract that frees a party from their obligations or contractual obligations if an extraordinary, unforeseen event occurs outside of the performing party's control. Oftentimes, and we'll, I think, got a slide on this a little bit later. Oftentimes, so we'll discuss it more in depth later, but oftentimes the standard force majeure provision that you might see in a service provider agreement may not be the most appropriate for these types of event and facility contracts. So we'll go over in a little bit more detail later in this presentation about what you should keep in mind when you are negotiating and designing a force majeure provision. Indemnification, this is also a common just contract provision in general, but it's also very important for these types of event agreements. And these indemnification is essentially a legal agreement whereby one party promises to compensate the other party for claims that the other party might receive for the indemnifying party's negligence, acts or omissions, or other events that are specifically set forth within the indemnification provision. So here we often try to negotiate. Oftentimes when you get a form agreement from a hotel or conference center, there'll oftentimes be one-way indemnification whereby the sponsor, the event host, is indemnifying the hotel or the convention center. It's important to ensure that there's mutual indemnification, and that also that the promises you're making to the hotel or the convention center aren't overly broad and can lead to high unexpected expenses that the sponsor may not be prepared or capable of paying, or for events that they shouldn't be responsible for to begin with. Insurance provisions are frequently included in these types of agreements, and Andrew touched on this briefly in the lead up to this slide, but they often require the event sponsor to include or to maintain insurance through the length of the contract term for liabilities. That's general liability. If automobiles are going to be involved, automobile liability insurance, collision insurance, and then other types of insurance that might be specified or set forth within the agreement. Again, these are generally one way when we see the agreement come from the facility, but it's important for the facility to also maintain insurance at appropriate levels given the scope and size of your event. Oftentimes here, the facility might not be willing to negotiate too much on what insurance levels that you're required to carry. So it's key that you check in before signing an agreement with your insurance broker to make sure that you've got all the applicable levels in place. And then also, if you don't, that you can get those coverages fairly easily and at an expense that you can afford. Oftentimes, these types of agreements will also require you to ensure that any subcontractors that you're using maintain similar, if not the same, levels of insurance. So you'll want to make sure that you're coordinating your kind of secondary agreements. You've got this agreement that's kind of overarching and stipulates what all of your contractors will need to have in place. You'll want to make sure that the agreements that you have in place with those contractors are clear about the expectations as well.
Yeah.
Food and beverage commit. Oh, go ahead, Andrew.
And Brian, just to jump in here on the insurance.
Yeah, absolutely.
It's also important to make sure that the insurance policies that you do have can meet the venue requirements, one, but it's also important to ensure that the event-related policies that you have don't exclude the types of activities that might be occurring at your event. If you're going to have some type of recreational, event like a race or some other type of fitness, activity, or you're going to have an outing to go-karting or bowling, that you don't have exclusions in your insurance policy that are going to deny coverage in the event you have an attendee who's slips and falls or is otherwise injured at one of those recreational activities that surround your event. Or maybe you're going to have some type of fireworks display or a petting zoo or some other type of unusual risky activity. It's just important to make sure that your insurance broker is aware of what's actually occurring at your events so that your policy can be tailored to reflect those risks.
Great point. Thank you. Moving on down this list, if you're hosting meetings, so at the facility with which you're contracting, they're oftentimes going to have meetings and food and beverage provided at those meetings. So the contract terms will, of course, lay out all the requirements, timing, when you need to have menus in, when you need to have expected and finalized guest numbers, etc. But they'll also include minimums akin to a room block reservation minimum, benchmarks that you must meet with respect to food and beverage, or else penalties may be incurred. Oftentimes, if you're having a large event, you may be able to negotiate a waiver of any food and beverage minimums, depending on how many guests you're expecting. And that's all just going to depend on the nature and size and scope of your event. But something to keep in mind if you're looking for, like Andrew and I have said earlier, some flexibility for your event. Concessions, and we'll talk about this again a little bit more detail later on, but these are the free benefits that the hotel or convention center is providing to you as in exchange for your business, essentially. So this might be as small as free Wi-Fi for all of your guests staying at a particular hotel, free room setup, free room takedown, if you need chairs, tables, those types of things, those all could be included as a concession. And that's also an opportunity for you to negotiate. Oftentimes, when you get an agreement from a facility, an event facility, they're not going to have concessions in there, but it's something that you should ask for if there's something in particular that you want to have, and think that it should be included just as kind of part of the deal.
Yeah, other concessions that we see too are destination or amenity fee waivers for attendees, for example, if there's a daily resort charge, or free or discounted valet or self-parking in case the hotel location is primarily in a place that's accessible by car, where your attendees will be arriving with their own vehicles or rented vehicles, or reduced rates on staff rooms to help minimize some of your organization's own travel expenses in putting on the event, or even planning for the event. And paying for the costs of pre-planning visits if there are going to be any site visits. One thing that we see often with concessions is that in the event of underperformance, that concessions can be withdrawn. We generally suggest striking that type of term because you're agreeing in most cases to attrition, and the attrition is what the anticipated loss is going to be. So if the hotel was willing to offer you a set of sweeteners, if you fully performed, they should be willing to offer you the same sweeteners if you're paying them for their lost revenues or lost profits.
That's absolutely right. And it's oftentimes as simple as just striking half a sentence to ensure that regardless of whether you don't meet the expected room minimums, that you don't, those concessions or benefits are pulled out from under you without not meeting your expectation.
Yeah, and Brian, we received a question here about indemnification for the acts of attendees and whether groups should try to limit the indemnification obligations to covering attendees at all, or covering attendees when they're just participating in scheduled activities. What are your thoughts about that?
Yeah, so I would think that so in most instances, hotels and convention centers are going to initially ask the event sponsor to indemnify for attendees. I often strike that and limit the scope of indemnity to the folks that the the sponsor has control over. So its directors, officers, employees, subcontractors, and other representatives, and try to exclude attendees from that scope of, from the scope of indemnification because you don't have control over an attendee's actions once they come in, and so it's not necessarily fair or reasonable to for the event sponsor to be on the hook for the actions of those types of individuals where they don't have a control over them. I think that's also an area where hotels and convention centers push back frequently, but it's often I think it's worth trying to negotiate on that point almost every time.
Yeah, and sometimes venues just won't negotiate with you on that term, and they want the event host to be responsible for everyone that the organization is bringing with them, which makes your flow down provisions through your event registration agreements all the more important, so that you have recourse against particular attendees at the event that an attendee damages function space or their guest room, and the hotel is looking to come after the organization for payment, that you have the ability to look to your attendee to make you whole. That's something that's commonly seen. And Brian, we also got another question about liquor liability coverage. Should organizations have their own liquor liability coverage, and should they deal with it on a blanket permanent basis or maybe on a just event by event basis? What do you think about that?
Sure. Oftentimes I haven't seen it required that often, but I don't think it's a bad idea to have liquor liability insurance. With respect to liquor liability, I often try to change the language or negotiate the language to put that sort of liability on the individual or on the vendors that are serving the liquor, and also ensuring that there are clear representations and warranties in the agreement to that the vendor is going to be checking identification. They've got someone properly trained in serving alcoholic beverages. And then also, when paired with a strong indemnification clause on the part of the hotel or the convention center, that can limit liability or protect against liability for the event sponsor. As to whether it should be kind of permanent or on an event by event basis, I'm inclined to think that it's probably okay to just do it on an event by an event basis. If you're expecting liquor, alcoholic beverages to be served at an event, and the hotel or the event facility is requiring you to have some sort of insurance, then I think it's fine to do it on an event basis. But I don't think it's necessary to have it on a permanent basis.
Yeah, and sometimes we'll see, one of the things that venues will do in their agreements is reserve the exclusive right to sell, serve, or dispense alcohol. And organizations have run into trouble before where individuals attempt to bring their own alcohol into events, either visibly or secretively. And it's important that you have your own internal rules that regulate attendee conduct to make clear that alcohol can only be dispensed through the approved, bartenders at the hotel. And we've seen venues that have, attempted to cancel future agreements because of violation of that rule, because it could put the hotel's liquor license, at risk ultimately.
Absolutely. So the next bullet on our list is attrition and cancellation. Similar but distinct concepts here. Attrition is when you've made a room block commitment to rent, say, 100 rooms over your event dates, but you don't meet that commitment. And then cancellation are provisions that deal with in the event that either you or the event facility cancels the agreement altogether. We'll go into those a little bit more detail later in the presentation, or we can actually do it now. I see Andrew kind of flip forward. And I think on the previous slide, it mentioned that oftentimes, at least with respect to cancellation, there are no provisions often dealing with what happens if the hotel or the convention center cancels on you, and that cancellation isn't warranted for some sort of force majeure event or some other agreement between the parties. And so that's something that's going to be vitally important for you to put in to ensure that, obviously, you're going to be on the hook for liquidated damages if you cancel the event without cause or for a reason that's not permitted under the agreement. But you could be really left in the lurch if the hotel unexpectedly cancels and you need to quickly find another facility that can accommodate the size and scope of your event. And so those types of provisions are critical to make sure that you're in there.
Yeah, sometimes you'll see hotels will try to limit their liability to the cancellation fees that you would have to pay if you cancel, but that may not be a fair approximation of the harm that your organization may suffer if a hotel terminates the agreement that you have with them to host your event. It may be more expensive for you to find an alternative facility, or there may not be an alternative facility available. You may need to cancel your event and refund attendees their registration fees. So those are provisions that are important when you're addressing cancellation by the hotel.
Sure. And relatedly, attrition, as we mentioned, is if you don't hit the minimum benchmarks that you've agreed to in the agreement. And usually there's, and that should be assessed against an allowable shortfall and any room block adjustment that we mentioned earlier. So if a year out, you're allowed to adjust your room block by up to 20% by reserving fewer rooms than originally anticipated. Any attrition should then be measured against that adjusted room block commitment. And then in addition to that, it shouldn't be that you hit 100% of your adjusted room block commitment, but frequently we see if you attrition fees kick in if room pickup is either 70 less than 70 or less than 80% of what the adjusted room block commitment is. One thing to keep in mind when negotiating attrition fees is oftentimes hotels will be agreeable to negotiating the fee based on lost profit. So it will be a percentage, usually 70% or so, of what you would have owed under under the attrition formula. And the attrition formula is essentially a comparison of the room pickup that you actually have versus what you have committed what you've committed to pick up, and then multiplied by that percentage, 70 or 80%, to reflect what the hotel's lost profits are. Here it's also important to try to negotiate that pickup or attrition fees are based on cumulative room nights rather than each night. So if you've got a multi-day event, you want to make sure that attrition is based on your cumulative pickup over all of the dates of the event rather than an attrition fee for each night. So in the event that you don't hit the room pickup on night one, but you do kind of cumulatively, that you wouldn't be subject to any penalties. Also here, hotels will often try to exclude, late reservations or rooms that if event attendees are arriving early or arriving late, business that they wouldn't have otherwise obtained but for your event. It's good to try and negotiate that those count towards your pickup and the fees that you are committing to pay, which helps provide some additional flexibility and mitigates the risk that you might be on the hook for liquidated damages if your actual room rates aren't where they need to be.
And one provision that could be really important in terms of shifting financial risk, both with attrition and cancellation, is when payment of any attrition damages or cancellation damages are due. And ideally, in the event of attrition, you want to have any attrition damages payable after the event and after all of the room night audits have been completed and there's been reconciliation against actual occupancy with your guest list and the hotel's reservation system. And similarly, on the cancellation side, rather than paying within 30 days of delivering cancellation, it's better to try and to get the hotel to agree or the venue to agree that you're going to pay cancellation 30 days after the event would have been held, or some other number of days after the event would have held. And that's going to incentivize the event venues to try and resell the space that you've reserved exclusively to a third party, so that the hotel or the venue gets paid by someone else, and that payment amount is going to be deducted and offset against any cancellation damages or attrition damages that you might owe. And if you've been hanging on this long, I just want to quickly share the CLE code. It's Events 2025, EVENTS 2025. So when we think about the double dip and what that really means, it's to prevent a hotel from recouping revenue both from your organization and a third party, either in the event of an attrition situation or a cancellation scenario. So if you underperform on your room block commitment in a hotel agreement, and the hotel turns around and is able to resell the room at a higher rate or even a lower rate, there should be some type of corresponding credit and obligation set forth in the agreement that requires the venue to make reasonable efforts to try and resell any type of canceled function space or food and beverage functions or guest room revenue that is going to be credited against any liquidated damages that you're going to owe. The second thing when it comes to the double dip is if you don't recoup and have an offset against damages that you're going to owe, and you have a measurement based on a lost revenue basis, an event venue may be paid for a room that's never used, but it's also not serviced, which means that the venue isn't incurring the cost of having to change linens in the room or service the room that it might be if you have an early departure from a room and there's some type of partial service. We talked a little bit about the timing of payment. These provisions also will come with graduated payment in the event of cancellation. So the further out you cancel, the less cancellation damages you owe. Closer in time that you cancel, you may have to pay more or 100% of what the estimated room revenue or food and beverage commitment is. Those payment timelines are generally negotiable, as are the percentages. So that's something that you can always look to try and push payment obligations further out in time and closer to the event dates in order to try and protect your organization in case you need to make a late cancellation decision.
And just to quickly jump in, you may also be able to negotiate either within the agreement or after the fact, once you discover that a cancellation is going to occur or is necessary, that those liquidated damages might be waived or applied toward a future event that is held within a year or two of the originally anticipated event. So that's something also to keep in mind as a way to maybe blunt the potential damages that your organization may be facing.
Yeah, and sometimes a hotel may sell out an entire night, even if you've dropped rooms, and it really depends on what your agreement says, whether your organization will be responsible for the lost rooms or not, including any permissible allowance, and whether the venue has an obligation to mitigate damages. Generally speaking, if there's just a liquidated damages provision, you're agreeing on in advance what the damages to the venue is, and they have no obligation to mitigate. And so if you want to recoup credit for your rooms or functions that are resold to third parties, you should have that expressly set forth in your agreement. And also the timing of when rooms are resold is really important. Sometimes agreements will contain provisions that your rooms are going to be on a last sale basis, which means that every room in the hotel needs to be sold out before you're going to get credit for filling your block. But that may not necessarily account for the expectation that a venue may have at the outset of negotiation. You could fully perform the block that you're reserving, and if you're reserving less than the full venue, the rest of the hotel could be empty, and the venue may not be any worse off. So it's important to try and get venues to agree to sell your rooms first in the event you're going to return rooms or you're going to have underperformance. Why don't we talk a little bit about force majeure, Brian? And I know this has been a hot topic in recent years, particularly in the post-COVID universe, and in the pendulum that swings between you know how accommodating hotels have been with negotiating these more recently.
Sure, absolutely. So as you mentioned, Andrew, these oftentimes are a forgotten clause until I think COVID came about, and event cancellations were there were many of them, and the standard force majeure clause generally aren't enough, and so it's important to design these clauses to include provisions that protect you in the event of some unexpected circumstance that essentially prevents your event attendees from actually attending the event or coming to the hotel. There are five main elements in a well-drafted force majeure clause. The first and perhaps one of the most important is the list of potential events that qualify as a force majeure event. So this, your typical enumerated list would include acts of God, threats or actual acts of terrorism, floods, fires, etc. But don't just limit it to emergencies. Be specific. Include that laundry list to ensure that the type of force majeure event that may arise is covered, and it eliminates or mitigates the potential of arguing over it in a dispute later. Then there's the second main element is a catch-all clause, and this is something that's kind of just appended at the end of your laundry list of events and similar emergencies or similar unforeseen circumstances. The standard for a force majeure event. How restrictive is the provision for it to come into effect or to be applied? Make sure that it's not overly restrictive and in favor of the hotel or the convention center, so that the hotel or convention center has a reasonable argument to deny any force majeure claim that you may make. And then it's also important to be specific about what the effect of a force majeure occurrence is. For example, is your performance excused for the period that the force majeure exists, or are you allowed to cancel the agreement and be done with it? Depending on what you're expecting for your event, different or the nature of the event, it just may depend on what's preferable to you, but something to definitely keep in mind and negotiate. And then also notification provisions. Are you or is the hotel or convention center required to give you advance notice? And what are the parameters around that advance notice for you to invoke the force majeure provision? It's ideal to remove any strict deadlines or other conditions that may preclude you. So if you fail to provide written notice by a particular deadline, that may preclude you from invoking the force majeure provision, even if a force majeure event has truly occurred and is preventing your performance. Again, the idea here is a key is a focus on flexibility.
Yeah, and oftentimes you'll see clauses that try and limit circumstances to things that are unforeseeable or that are just emergencies. And the purpose of this clause is to agree in advance on a certain type of event and the impact that it's going to have, that's going to excuse the ability to perform as you initially agreed on or to exit the agreement. And so those circumstances are inherently foreseeable because you're agreeing in advance that if any of these things occur, or if something similar occurs, or if any other thing that's beyond our control occurs and has this impact, that we're going to get out. And in terms of just examples of like non-emergency situations, and we received a question about this that could be included as illustrative examples in a force majeure clause. That might include corporate travel bans, or it could include inclement weather, or it can include suspension of government funding or some type of government order Doesn't necessarily need to be an emergency declaration, but it could be some type of transportation interruption or some other circumstance that's totally beyond either your control or the venue's control, that necessarily isn't an emergency, but it might impair the ability to proceed with the event. And oftentimes we'll see, we got another question about this too, about what about carving out payment obligations from force majeure clauses? And that's really common. You should try to strike those and exclude payment obligations from being enforceable if there is a force majeure circumstance that allows you to terminate the agreement, or that may excuse performance and allow for delayed payment or mitigated payment in the event that your ability to perform has been impacted. In some types of agreements, you may see a reluctance to agree to removing a carve-out for payment obligations, in which case you can recast that carve-out to continue to apply in the event that there's some type of failure in the banking systems that prevents payment from being made on a timely basis, to avoid some type of strict breach the event payment is late because there's some type of natural disaster, or I think in more the modern day and age, some type of IT incident that would shut down or affect the banking system. But this type of provision is really important, and I think as with all of the types of provisions we've discussed up to this point, their relative importance is going to depend on the nature of your event. And perhaps going with a gold standard force majeure clause for an event that's going to happen 2 months from now, you may not need to address risk in the same way that if you're contracting for an event that's 2 years from now or 3 years from now, or it might be located in an international destination or an area where many people have to travel to, as opposed to a location that's going to be nearby for many of your attendees. So it's just important to approach everything with a tailored, risk-minded, business approach in mind, because you may not always get all the changes that you ask for. You're going to have to, negotiate based on the relative priority and tolerance.
Absolutely. And I think here, especially in the wake of COVID, hotels and convention centers are going to be hesitant to accept a force majeure claim because they could be losing substantial business. And so specificity, I think, is ideal here, so that that the hotel or the event facility can't claim that what you're actually saying is a force majeure event is in fact not a force majeure event. And oftentimes litigation is cost prohibitive in the event here, if it occurs here. So specificity just helps mitigate risk that there will be a dispute moving forward, and helps clarify what rights you have as an event sponsor when it comes to canceling for some sort of unforeseen or enumerated event in the force majeure clause.
And clarity is really key and important. Convention centers are often known for not being the easiest to negotiate with, either because they won't accept red line markups to the template agreements that they present, or they want all the changes presented in some type of rider, or as attendee pointed out in a question, perhaps they won't agree to a mutual indemnification provision, and that's their policy, and you have a business risk decision to make on whether you want to move forward with a particular event at all. But convention centers are just different. Brian, I don't know if you have any additional thoughts about some of the differences between the governmental facilities and privately owned facilities.
Right. So, I mean, that's a great point, Andrew. Oftentimes, convention centers are owned by a governmental authority, either a city or a state governmental agency. And so they may claim that they can't agree to a mutual indemnification clause because they're restricted by a state or municipal law or regulation on the books. And so there it's critical that you don't take their word for it, that you do the research and actually see if they are in fact restricted by law from agreeing to indemnify for its negligence or other acts or omissions. And to the extent that they are, restricted, I think a few simple words can still help mitigate risk, and that's adding, to the extent permitted by law, hotel or convention center will indemnify the event sponsor for whatever the indemnification, the enumerated list of indemnification coverage is. I think privately owned convention centers may be more amenable to negotiating on indemnity clauses, but I've seen them be hesitant as well. They don't have the fallback as to, we can't do this. We're not permitted under law, but they still might be hesitant to do so. But if you're equipped with the knowledge of, what the restrictions under law are, or that no restrictions exist under law, then that can help you when negotiating with a convention center that are hesitant to negotiate at all on these provisions.
Yeah, and sometimes the inflexibility of particular convention center sites, you can try to figure that out through your due diligence on the front end. If you issue an RFP, include requirements for the types of revisions that you would want to see. And sometimes organizations just need to make a business judgment call about whether they want to have their event in a particular city or location or willing to accept the terms. Or whether they need to look to a different location in order to get more favorable terms. And just lastly, I know I touched on this at the beginning, but when it comes to event codes of conduct, the latest trend is to regulate, to try and protect your attendees from misconduct of others, whether it be your own attendees or your staff. It's important to have a clear policy in place in order to mitigate risk in the realm of employment practices, as well as member relations, and importantly, defamation, by ensuring that complaints are handled in a discreet and confidential manner. It's important to put attendees on notice of the type of things that they can and can't do, and to try to attend some type of acknowledgement to those rules prior to your event occurring, normally through the registration process, and agreeing that these rules will apply if you attend. In the event that you receive a complaint that your code of conduct for the event has been violated, or there's concern about attendee behavior, you really do need to investigate that complaint, and you should have a process that recognizes some notice to the person who's been accused of misconduct, and providing them an opportunity to be heard before an adverse action like suspension of their membership or expulsion from the organization, or barring them from attending future of the events is warranted. I know we've had a lot of ground to cover today. There's certainly no shortage of topics when it comes to events, but this is just a good snapshot, I think, of some of the issues that regularly come up for many of our nonprofit organization clients. I know there are a few questions that we weren't able to get to today. We'll be following up with you separately, and if you drop a question into the question and answer box, we'll be sure to follow up with you about that. But thank you so much for your time this afternoon, and if you have any questions, please feel free to reach out. And if you're attending for the CLE, again, that code is events 2025. Thanks. Have a great day.